Okay. Everyone hear me? Everybody have a good week? Good. Okay, 17%. Holding on there. There's not going to be an armed rebellion anytime soon, maybe. Maybe that's when it gets down to like 3%. I'm not sure.
You're asking the same people.
I don't know. I don't look into the actual data of the YouGov poll. It's The Economist that does the poll, I think, every week, and it's on Wednesday. It's published every Wednesday, and I just look on Real Clear Politics to see what the number is. I haven't actually looked into the survey data. Maybe I'll do that by next week and see how many people there, see their survey tactics. Okay, so last time we were on the tail end of our discussion about the Commerce Clause, and we had basically we said from Lopez, from United States versus Lopez in 1995, we have entered, as most legal scholars will tell you, we've entered a new era. The same way that it's pretty manifestly clear that the court entered a new era in 1937 with the Jones and Laughlin Steel Corporation versus the National Labor Relations Board, where the court just had a new way of thinking about the Commerce Clause and started going a different direction. A lot of people will say that Lopez and Morrison mark a new turning point. And so it looked, after Lopez and Morrison, it looked as if the court was poised to backtrack, even begin to maybe overrule some of the New Deal cases on the Commerce Clause. In fact, a lot of people were anticipating that the court would be poised to overrule the most controversial New Deal Commerce Clause case, and that's Wickard versus Filburn with the farmer. And so they had the chance to do exactly that in the very last Commerce Clause case that we're going to discuss today, in the Gonzales v. Raich case. So what's going on in Gonzales v. Raich? They want to tell me just...
Locally, marijuana was being raised.
Mm-hmm.
And after that, I can't tell you how that led to the Supreme Court.
Yeah. So the Angela Raich had I believe it was a terminal illness, and she had tried different forms of treatment for, I don't know if it was pain or her appetite, but her doctors, her physicians had said, okay, well, if you want to try marijuana in a clinical capacity, then we're not going to object. And so she grew 6 marijuana plants on her own property and was using that medicinally. Consistent, as I understand, consistent with what California law allowed.
No buying or selling?
No. She was growing it there on her own property for her own consumption, and not buying or selling. Well, what was the problem with what she was doing? It was legal under California law, completely.
Not legal under federal law.
Not legal under the Controlled Substances Act. Marijuana, even to this day, is still a Schedule I drug under the Controlled Substances Act. And so when the feds found out about her marijuana plants, they destroyed them and seized the plants. And so she sued, and her argument was, what about the Controlled Substances Act?
It's not commerce.
It's not commerce. It's not a valid exercise of Congress's power under the Commerce Clause. Yeah. So here's the issue. How is Angela Raich any different than Roscoe Filburn? Like I said, some people were thinking, okay, finally we have a more right-leaning Supreme Court who has a much narrower construction of the Commerce Clause. We have a court that's ready to overrule Wickard and to roll back the scope of federal power under the Commerce Clause. It's not what happened. But if you're standing there before the court and you know that the court is not going to overrule Wickard, well, first of all, tell me, is Angela Rach, is she similarly situated? Is this just the same situation?
She was raising it for her own use.
Well, Roscoe Philbin was growing the wheat for his own
But
use.
it's illegal, unfortunately.
It's, okay, well,
And
does,
otherwise, you might think it is.
is that a distinction without a difference? Does the fact that that marijuana is contraband and wheat is something that was just being regulated, how does that difference make a legal distinction?
There is no marijuana that is legal in the government.
Uh-huh.
So, actually, it's kind of a sleight of hand that got the government, even to the federal government, to say even, oh, okay, well, we won't bother that, even though we actually have the ability or the right or the law to do that. We'll be just good guys sometimes whenever they say, I guess depends on who the Attorney General is.
Yeah. Big difference in Eric Holder to Jeff Sessions in their enforcement. But I mean, well, I guess my question is, does the fact that marijuana is just plain illegal, how does that either expand or diminish Congress's power under the Commerce Clause to regulate something that's confined to someone's own property and not leaving at all?
Well, the thing I don't understand is in the middle of toward the bottom of the first paragraph, or in the middle, it says local use affected supply and demand in the national marijuana market.
Ah.
Making the regulation of interstate use essential to regulating the drugs national market, but it's illegal. So what kind
Well,
of-
okay. I think you guys are.
As-if argument that doesn't even have to be made.
I'm sorry?
That's an as-if argument that doesn't even have to be made.
How do you mean, as if?
As if that made a difference, because.
That's my question. Does it? If you're Angela Rach, what do you say to the court, or if you're Angela Rach's attorney, rather, what do you say to the court? Your Honors, this is different than, we are not asking that you overrule Wickard v. Filburn. This is different than the case in Wickard v. Filburn because
There's no effect on interstate commerce.
There is no market for marijuana.
there's that's not what Congress found in the Controlled Substances Act. There's a $33 million market of just because it's clandestine. It's illicit, certainly, but there's a market. If you're Angela Rich's attorney, this case is distinguishable from Wickard because I think that's the importance. Is in Wickard, the Congress was trying to regulate a commodity for the sake of maintaining a price. Congress here is proscribing outright and totally a substance, an entire article of commerce as contraband. Does that difference, does that distinction make a difference? And if so, how?
So not regulating the price,
Well,
as with the wheat. or the
It
whole
sounds
category.
like the argument under the Commerce Clause is not very beneficial to the what is it, plaintiff, I guess.
well, no, I mean the plaintiff's argument is one, overrule Wickard. That's kind of what they were hoping the court would do. Two, Wickard is still good law, but Wickard is not on all fours with this case, because in Wickard, what Congress was trying to do is to regulate the market. Here, Congress is outlawing a substance. So Congress has, when they're totally making something contraband, is not, that's less of a commercial enterprise. Or is it? Is Congress trying to regulate the price of marijuana?
Well, they use the words class of activities,
Mm-hmm.
so I guess they're comparing to the weed.
Yeah. What if I submit to you that the government's argument is, yes, Congress is trying to regulate the price of marijuana.
To zero because it doesn't exist.
To zero or to inflate the price.
Well, the effect is to inflate the price.
Exactly.
But that's not their intent.
Isn't that exactly what the government was trying to do in Wicker under the Agricultural Adjustment Act, to regulate the market such that the price of certain crops would maintain a certain height?
Yes.
So isn't it then also the case with the Controlled Substances Act that Congress has proscribed a certain plant so that the value, so that its supply is contracted and its demand will go so high that it's not affordable to John Q. Public?
He didn't say that today expressly.
That's if you listen to the oral arguments and if you read the briefs, that's the very argument they made. This is exactly like Wickard v. Filbert.
That never has worked. Because in effect, the effect is that people provide a supply, and the only way to keep it from being used is to eradicate it from the market.
But is it the province and prerogative of the court to look at laws and judge their constitutionality on the basis of whether the laws work, whether the laws are good policy, whether this policy actually works, or that Congress could have rationally found, there was a rational basis for Congress to, is that what the courts are for? Wouldn't you then have a court that's operating in a legislative capacity?
Yeah, they're trying to regulate prices.
They would have to use some common sense, which courts don't have to use.
Well, don't have to or can't under our system.
Shouldn't.
Solomon used some common sense.
Solomon was a monarch. You're talking divine right of kings, and you're talking about the rule of law. So, I mean, under our system, Congress, the court's inquiry is not, the Controlled Substances Act is not working. The question is, could Congress rationally believe that proscribing marijuana entirely would regulate the marijuana market such that it would be so rare and the supply would be so contracted, the value would skyrocket and nobody could buy it. Ergo, no one could use it. In that case, it's not very different than Wickard v. Filbert. Do you see what I'm saying? So we can harp on this case, all we want to. From the government's perspective, in this case, Angel Rach is in the same shoes. She's standing there, crying, holding the same pitchfork. She may as well be in the Grant Wood painting with Roscoe Filbert. It's the same case. Do you see what I'm saying? It's the same case for Congress's argument.
In the second paragraph that's about Justice O'Connor, she has this funny thing about
but she dissented
that a single courageous state may serve as a laboratory.
Yes. Now,
so she's arguing state
so
versus federal.
that's what a lot of people were thinking that the decision would come out to. What she and Justice Kennedy are saying in the dissent is the kind of spirit of the legal and academic community as they were hoping this case would turn out. The notion of the new federalism. And so I was going to say exactly that the dissent in this case actually is a very good expose of the new federalism that was exhibited by Justices O'Connor and Kennedy and still to some extent to the court today. This notion of the states being the laboratories of democracy. and that they have a separate sphere into which Congress has very limited right to intrude. And so that's what Justice O'Connor says in her dissent. Hey, she's to my recollection, she says something to the effect of, if I had voted for, was it Prop 14, whatever proposition it was on the ballot to legalize medical marijuana in California, I wouldn't have voted for it. But as a matter of my judicial philosophy and my understanding of federalism under the Constitution, I don't think the federal government has the prerogative to enforce federal law in a way that would conflict here with California's own prerogative to handle their own drug laws. And so that was her and Justice Kennedy's general philosophy of federalism and the relationship between the states and the federal government. But I think that kind of misses the issue. The issue here is the Commerce Clause. Does Congress have the power to have something like the Controlled Substances Act under the Commerce Clause? And if you're looking at the strict precedent, the cases, the government's argument is this is no different than Wickard. This is the same case, really. And if it's the same case, we should have the same outcome. Isn't that what conservative justices want? Is uniformity of outcome, expected outcomes?
To stick to precedent.
Stick to precedent.
What about environment, science, progress, things that they didn't know before that they know now,
Uh-huh.
and the whole panoply of life that is moving on that we have to face?
Things that are important. I'm going to speak to you as one of the okay. Those are things that the legislature is concerned with. If people are so convinced that this application of the Controlled Substances Act is so draconian, is so backwards, then they take that up through the democratic process. It's not the province of the courts to usurp the democratic prerogative. You see what I'm saying?
Then we'd have segregation for a long time.
That's the other side of the argument, right there. At what point is you have this tension between democratic principles and the Lex Rex, the Marshallian rule of law principles, and when it comes to our Constitution, those two pull at each other in a lot of instances. You see, and so I think that's a good example.
That's a good thing. We want it that way.
Maybe. Okay. Any questions about this case? We could harp on it. It's interesting. Let me say this really quick. Okay. If you look at Lopez and Morrison, to the two cases that begin to backtrack to a more restricted understanding of the Commerce Clause, the justice who was very committed on both of those decisions to striking down an act of Congress, didn't write either of the opinions, but was solidly on board, was Justice Scalia, the late Justice Scalia. In this case, Justice Scalia is the one who is. He writes another concurrence in here that I didn't speak about. But he is the one who is gung-ho defending congressional power here. And it's one thing that was interesting in all of Justice Scalia's decisions. Justice Scalia was in everything. He was of course, he's regarded as a very conservative justice, and he exhibited that kind of philosophy with respect to the Fourth Amendment, searches and seizures. He had a very broad and robust view of individual rights when it came to the Fourth and Fifth Amendments, as opposed to the government's right to search things. He had a very broad and robust view of religious liberty. And he also had a very narrow and restrictive view of congressional power, except in all of those instances if you threw drugs into the matter. If there were drugs involved in a case that Scalia was looking at, it messed him up. So, for instance, who had my freedom of religion class last semester? Remember that case, Employment Division versus Smith, where Scalia writes the opinion and he totally backtracks and functionally erases all of this line of cases that are very protective of religious liberty because it's involving Native American peyote use. Remember that case? Then in the Fourth Amendment cases, you see a similar thing on Scalia's part. In this case, the oral arguments are funny because the council keep referring to these cooperatives. There are these cooperatives in California at the time that were involved in growing and distributing medicinal marijuana, and Justice Scalia keeps on referring to them as communes. It's like a Freudian slip almost. He said, "Well, tell me about these communes that keep on growing." So he has in his mind just a bunch of hippies that are that are just engaged in whatever kind of debauchery. But that was always something really funny about Justice Scalia is if you added drugs into the factual equation for a case, he would go off of his compass.
Is it surprising that Thomas and Gonzalez and Ray,
Mhm.
that Thomas said it would be unthinkable in the early days that Congress could prohibit cultivation, possession, and consumption of a plant?
Yeah, this is the third time that we've seen Thomas make that very same argument. In Lopez and in Morrison, Justice Thomas has had issued a concurring opinion saying, "Hey, this whole third category of substantial effects, I don't buy it. I do want to reverse Wickard. Wickard does not comport with the original meaning of the Commerce Clause because Thomas is an originalist. Justice Thomas is a pure originalist." And we'll see when we read our final grand finale fun case, the Obamacare case from 2012, you'll see that line made one more time from Justice Thomas. So yeah, that's his concurrence here too. He would say, hey, marijuana, good or bad, the framers had no intention of vesting Congress with the power to regulate the growth of a plant on someone's private property, let alone wholly within one state. Any questions before we move on to taxation?
So their goal was actually the regulation of the price of marijuana.
That was the argument that it was made. To my knowledge, in the legislative purpose section of the Controlled Substances Act, I don't know if that was made mention to in the legislative record that Congress was out to. Oh, we really want to drive the price of marijuana up, but for the purpose in oral arguments before the Supreme Court, that was made mention. That was described as Congress's enterprise to make it seem like to make this case, to make the court understand that this case is very much like Wickard. Because the distinction that the plaintiff had was this is different than Wickard. Because in Wickard, you actually had it was more pertaining to commerce because you had a regulation of commercial activity. Whereas here you have an outright prohibition. And the government said, no, it's pretty much the same. The prohibition is a market regulation. Prohibition is a price. It is price regulation. We want the price to be as high as possible. Yes, sir.
Well, the reason that marijuana is almost all cash business now is because they're afraid that at some point there will be some kind of change, and then what they've been doing will be illegal. That's what I've read.
Yeah.
That's all.
Well, it's not speculative fears. That's exactly what happened in the transition from the Obama administration under Eric Holder's Justice Department to the Trump administration with Jeff Sessions' Justice Department. As you had a memo, Jeff Sessions in the Justice Department circulated a memo. It's like, okay, we're going to enforce the federal law now. Whereas under the Obama administration's policy is we're not so much going to enforce the Controlled Substances Act with respect to marijuana. So yeah, when it comes to companies that are able to get capital to get people to invest in cannabis-related businesses, they're on shaky legal ground here because they may be in perfect compliance. If you have a Denver-based cannabis company, they're in perfect compliance with Colorado law. But they are trafficking drugs under the Controlled Substances Act, federal law.
So that's why more investment is going into Canada than.
Exactly. Exactly. Mhm.
So before we leave the Commerce Clause, could you say, or would you be willing to say something about what you think the limits of the application of the thing is?
Glad you asked. So like a
You yourself.
recap? Like, I'm sorry?
You yourself.
Like like just kind of a recap of how
I'm just wondering, I mean, we're all thinking, how can commerce be everything? And I'm just wondering,
Well,
can you?
I think if you look at just Lopez tells us that the fears or the hopes that many people had leading after the New Deal and the Civil Rights era cases that commerce is everything is not true. And that's because in Lopez we saw a very clearly articulated limits on the Commerce Clause, what is and what is not. That there is a distinction between what is truly national and what is truly local. That distinction is in place. Because that is what some people hope for, and some people feared under that New Deal, under all of the cases from the New Deal and the Civil Rights era, that hey, everything's commercial. So that means Congress has functionally, even if we can say in theory Congress is a government of limited powers, but functionally, given the commercial nature of dang near most everything, then Congress has plenary power, has general police power. And so Lopez tells us that's not the case. And so under Lopez, Morrison, and Gonzales v. Raich, we have the modern standard of the Commerce Clause. And I think I gave you the back page of this here. It says Modern Commerce Clause Analysis. And so we'll go through these really quick. There are essentially three categories of regulation. Congress's power to regulate under the Commerce Clause. Three categories. One is the channels of interstate commerce. These are the interstate roadways, not just the interstate proper, but other highways in which interstate traffic is traveling, navigable waterways, airways, the internet, the avenues, the channels on which the articles and persons of interstate commerce move. Okay? Congress has the power to, and Congress has very, very broad power. I can't think of any decision that's in any way limited or kind of scaled back Congress's power to regulate channels. Second one is the instrumentalities, the persons and or things which are traveling in interstate commerce. So anything that's moving across state lines, Congress can regulate. Once again, not very questioned. This is even an originalist, even Justice Thomas would agree with these two. The third one is where you're going to have all the litigation, and where really all the litigation has been. And that is activities that substantially affect interstate commerce. Intrastate, local activities. So you have activities that are going on in which people and things are not getting on the channels, and they're not involving instrumentalities that are crossing state lines, yet the activities themselves, while local, are such that they affect the interstate commercial world. And then, on top of that, there's a corollary. We have to understand. We have to understand Gonzales and its affirmation of Wickard versus Filburn. That when you're looking at whether an activity, a local activity, affects interstate commerce, you don't only have to. You're not confined to looking at just an isolated activity. The court will look to whether Congress could have found that the cumulative, the accumulation of all kinds of instances of that activity would have affected interstate commerce. So you can look at it in the aggregate. That's the notion that we get from Wickard and from Gonzales C. Raich. Then we have to understand, but any activity that would come under this prong, is going to be subject to the Lopez factors. Because there are certain activities that the court is going to get immediately suspicious of. They're going to apply a much stricter scrutiny to if they are non-economic activities. If they are non-economic in nature, then you have triggered a very strict scrutiny from the court, and the court is almost never going to permit regulations of non-economic activities. So an example from Lopez is mere possession of a firearm. Just possession of a firearm by itself is not an economic activity. So these are the four Lopez factors. One, is the activity itself economic or non-economic? Two, does the statute express a jurisdictional hook? So this is what we talked about before. If you read modern federal legislation that's passed with reference to the Commerce Clause, it will always reference it shall be unlawful for anyone who is engaged in interstate commerce to XYZ. Or it shall be unlawful for anyone to do XYZ in a way that affects interstate commerce. And there's two ways they'll do that. Congress will either write into the legislative purpose section of the statute that, for instance, like the Civil Rights Act. Civil Rights Act, Congress made a legislative declaration that racial discrimination, sex discrimination, religious discrimination in employment and public accommodations, etc., affects interstate commerce. That was a legislative finding and a legislative purposive statement. Then they can say it shall be unlawful XYZ. Or, that's one way they can do it, or they can make, especially if it's a crime, if they're writing a criminal statute, they can make interstate commercial affectation an element of the crime that must be proven. So they can say, for instance, if the elements that the government must prove in order to convict someone are they possessed a contraband, knowingly possessed contraband while having a felony record affecting interstate commerce. So Congress can make interstate commerce being affected an element of the crime that a prosecutor, that a district attorney would have to prove. You see the two different means there of getting that hook, that jurisdictional hook for interstate commerce? So that's the second factor. 3, does the statute's legislative history contain references supporting a nexus between the activity and interstate commerce? So is there anything that we can look at from Congress's discussions, from all the debates in Congress, from everything that they looked into, that they could have rationally found, yes, this activity that we're trying to regulate does indeed affect interstate commerce in a way that concerns us. And that's what they said about the firearm, the School Zones Act in Lopez. The mere possession of a firearm, we don't see that Congress really looked at anything, or Congress had any basis to believe that just merely possessing a firearm, wherever it was, would have affected commerce, or its effect of interstate commerce was so attenuated that it's negligible. And so that brings us to the fourth element. The fourth factor is the regulated activities connection to interstate commerce too attenuated. So those are the factors that will help us decide if an activity, a local activity, an intrastate activity, will sufficiently affect interstate commerce such that it can be regulated by Congress. Activity. Now, next week, we're going to be discussing if Congress has the power to regulate inactivity. If Congress can regulate activities, even if they're intrastate, local, can Congress regulate things that are not happening?
Like not throwing pot.
Now I've got you on the hook. Now you'll come back next week. Because we're going to talk about the Commerce Clause one more time. That's going to be our grand finale case, the Obamacare case. Yes?
What kind of activity?
Well, so,
Like a fair? Stay tuned.
yeah, I mean, you can just, I mean, you can imagine any kind of activity. As long as it is along the lines of these factors, giving, as long as it's such that Congress could rationally find that it's economic in nature and that it's affecting interstate commerce.
What if the gun was manufactured in another state?
That's okay. So last time in the Lopez decision, that's exactly what Congress went back and did. When the court struck down the Gun-Free School Zones Act, Congress, so Janet Reno went and told Congress, hey, look, I read the court's decision. Here's what I suggest you do. Reenact the statute. Pass it again, except this time include in the statute the requirement that the gun involved had moved in interstate commerce. Now, like I said last time, I've owned a lot of guns. I've never, ever in my time ever seen a gun that was not moved in interstate commerce. Ever. Even if for instance, there's a fire, Anderson Arms here in Kentucky, the parts that they buy come from out of state. It's not like they're mining the metals here in Kentucky to make all the components of the firearm. So even components of the firearm. So now Congress has effectually overridden this decision because they have included, they've adjusted the statute, they've modified the statute to comport with the case law. It does the same thing. And since then, people have tried to challenge it, and the courts have said, no, it works now. Good with us now. All you had to do was just have the little mention of interstate commerce in the statute. Now everything's good. Okay. Hypothetical, then we'll have a break. The Endangered Species Act. Anyone familiar with the Endangered Species Act? Heard of it? Yeah. The crux of the act, there's lots of different parts to it, but the main section, the meat of the act is the notion of taking, and taking is a term of art in the context of the act. Taking a creature, an animal, who is listed as being endangered. Taking can be hunting, killing, capturing. There's a very, very broad definition of taking. Okay? But it involves animals. And it is passed with reference to the Commerce Clause. Let's examine.
Destroying the habitat?
That can be a taking. Is it a regulation of the channels of interstate commerce?
Well, of course,
How?
unless they came across the animal in that state.
But I mean, the channels being like the interstate highways, the navigable waterways, the internet, the airspace.
Is it the animal that travels or the person capturing the animal?
So, okay, let me narrow it this way. Let me narrow it this way. Someone, let's say Billy Bob, sees a Monty Python and the Holy Grail, in the intro and like the credits. It's like Mexican whooping llamas. So anybody seen Monty Python's Holy Grail? In the very beginning, it said this film was written and produced by 20 mountain llamas and like 40 Mexican whooping llamas. So you have the incredibly rare Mexican whooping llama that comes into Billy Bob's backyard on his farm. Okay? And he sees this Mexican whooping llama and he takes a shot out of it. He takes a shot, he wants to mount that thing over his fireplace. But the Mexican whooping llama is listed as an endangered species. So he is cited and he has to be held into federal court and is charged with violating the act. He argues, no, cannot apply. Because the act, as applied to me, to what I did, exceeds Congress's power under the Commerce Clause. All I did was shoot an animal in my backyard. So, is the law that restricted him from killing the Mexican whooping llama? Is it a regulation of the channels of interstate commerce?
No.
Is it a regulation of the instrumentalities of interstate commerce?
No.
Now, if he went on a hunting trip to Colorado to kill the northern variety of the Mexican whooping llama, then that may be a different thing. But this was in his own backyard.
Or if he was gonna sell the head to somebody else.
Exactly. If he was involved in the black market for Mexican whooping llama feet or something. So, but
How did the llama get there?
well, let's say it was born. It was born there. Let's say he lives in New Mexico, and it was born. I'm not sure. I haven't looked on Wikipedia to determine the habitat range of the Mexican whooping llama. But somebody look it up for me and find out. But let's say that it had spent its entire life in the state. It had never crossed state lines. Let's say it was tagged by the Fish and Wildlife Department. They knew that. They could confirm that. Because that's just speculative anyway. You can't base a conviction off, well, it may have crossed state lines. There's no way to prove that. So does it affect the instrumentalities?
No.
So it's this one, right? Has to be this one. This is where all the unclear ones come out. This category, the substantial effects.
Aggregate accumulation.
The aggregate accumulation of poaching of Mexican whooping llamas affects interstate commerce. Okay, that's exactly what the government said about Lopez, about possession of a firearm. Is the taking of a Mexican whooping llama in one's backyard an economic or non-economic activity? Non?
You'd have to argue from the preservation of species, preservation of the DNA, the range of genetic diversity that is necessary for us to continue to maintain our economic life.
Okay. But I mean, is the actual activity itself? Because I mean, I get what you're saying. I mean, because imagine if you've got what if like 2 miles down the road there's a business that has basically like a safari, domestic safari, where it's like, pay us $25 and we'll put you in a 4-wheel drive Jeep and we'll take you out into the woods and we'll let you take pictures of the rare Mexican whooping llama. People come from all around the country to flock to get a view of these rare, beautiful Mexican whooping llamas. Okay? But so it's certainly you have interstate commerce that's in the background, but is the act itself of killing the Mexican whooping llama, is that an economic activity?
In the case about the gun,
Mhm.
and it was decided that just owning the gun is not commercial,
Mhm.
just having the gun.
Just possession.
So possession, yes. What about shooting the gun?
Well, it's interesting you say that, because the counsel for the plaintiff in that case conceded a statute that regulated the discharge of a firearm would be economic, and we would not contest that. But that wasn't the statute. He didn't shoot the gun. He just possessed it. They found it in his locker.
Well, I'm just comparing it to the llama.
Uh-huh.
If he possessed it and looked at the llama, that'd be okay. But if he possessed it and shot the llama, that's different. That pushes it in a different category.
Sure, but
Hunting could be an economic activity in itself.
okay.
Couldn't it? I mean, even if you didn't sell it, there was some purpose an economic purpose in it, because like, you want to mount it on your, over your fireplace, well, that costs, you have to get somebody to help you do that, or do it yourself.
This guy's a taxidermist. What if he just wants the hair? What if he just wants the hair? I mean, I could tan a coyote hide myself.
Or to other things. Well, yeah, I mean, you're getting kind of far out.
How far out do you have to get out from under the Commerce Clause? That's the whole point.
Good question.
Yes, ma'am.
My uncle kept trying to get rid of the deer that was coming into his garden.
Uh-huh.
And he wasn't supposed to shoot
Yeah.
deer, but he did finally.
Yeah.
He said, we're in his garden, and he shot, and then he called and said, come out here and look.
Hey, I'm planting a big garden this spring. You can bet anything. If it's brown, it's down in my garden. So I'm not going to I'm not about to be Snow White up in my garden this year. Okay, deer can stay the heck out.
That's not illegal.
Well, okay, illegal or not, that concerns state law. White-tailed deer are not an endangered species.
No.
Okay, the Mexican whooping llama is, however fictional.
That's the preposition that we're.
So, okay, but remember, it doesn't necessarily have to be an economic activity. It's just that when you have an activity that's being regulated that is in nature, essentially non-economic, it triggers the court applies strict scrutiny. The government has to have a compelling interest in order to survive the constitutional scrutiny. So here, you have a very, very rare Mexican whooping llama. And the taking of it affects commerce. Even though it's not, killing the llama itself is not an economic, it's not an economic occurrence, not an economic activity inherent in itself. The diminution of the population of Mexican whooping llamas affects tourism. And it affects the broader ecosystem that does spread in, because let's say these llamas do a really good job of munching down kudzu. And kudzu, they're the only natural herbivore that eats kudzu. And kudzu or whatever it is spreading all over the country.
Yeah, sure is.
So you have different interstates. So I mean, you can imagine, but you can see the arguments on both sides. What I'm getting at here. We need not wax any more ridiculous than we have. But yes, sir.
Well, I'm gonna get more ridiculous.
Oh.
What if it'd been threatening his life? Would that have changed anything?
Well, I mean, you would have inherently. Okay, if it's a vicious, I mean, like I don't know the temperament of Mexican whooping llamas myself. I imagine they're somewhat congenial if they help produce Monty Python's Holy Grail. But I'd imagine if it was a vicious llama, that wouldn't affect the interstate commerce issue. You may have an issue with there may be some kind of defense to do it, like a necessity defense. Like I think in federal criminal law, there might even be a residual necessity defense for all kinds of different crimes. And then, of course, you always have the matter of prosecutorial discretion. Prosecutor looks at Billy Bob and is like, hey, dude was getting eaten by a llama. He had to do something. You know, if it's me or the llama, it's the llama, you know. And also you have jury nullification. You know, 12 honest men and ladies may feel very sorry for Billy Bob, seeing all the scars that he sustained from this vicious llama, and they said, we're not going to convict this guy. Okay, how about we take a break? Did you have something to say really quick?
No, I think I was just waving around.
Okay, I do that sometimes too. I try to use a regal wave. All right, let's take a break, and we'll reconvene shortly.
I still don't understand number 2 under both those factors.
The instrumentalities, that's just,
Now, does the statute include a hook, a limit?
okay.
Any hook you can make up.
I mean, hook
Well,
is
remember, it's just a factor.
What does hook mean?
The hook is the statute will make, just like the Civil Rights Act, the statute will make reference to, hey, we Congress had to pass this law because of the pressing issue of the activity that's being related, the pressing issue of its effect on interstate commerce. Or we think that this is a bad ordeal, whether it affects commerce or not, and we're going to we're going to regulate this to whatever extent we can, and so we're going to make affecting interstate commerce an element of the crime. For instance, there's lots of...
Bumps into another issue that's of parallel importance, is that the basic idea?
I'm sorry?
That it bumps up against another issue of parallel importance?
Not really. Let me give you an example. There's a case, I want to say there's a case back in like 2005. There's like a federal statute against owning or possessing like certain kinds of explosives, okay? Or manufacturing certain kind of explosives, something like that. And it went to the Supreme Court because one of the elements of the crime was that the manufacture of this kind of explosive had to be done in a way that affected interstate commerce. Because, arguably outside of that, Congress may not have authority to just regulate manufacture of explosives in somebody's house. But the issue was this guy had done it in such a way where he'd only done it in his house or something like that. I can't remember exactly how it went down. But even the court was unanimous, and Justice Ginsburg wrote the opinion. And she said, no, and this was just interpreting the statute. No, we cannot interpret the statute this broadly, the element of needing to affect interstate commerce, so broadly where it makes the statute apply to cases that Congress can't regulate.
So what part of what you just said is called the hook?
The hook is the reference in the text of the statute referencing interstate commerce. It's basically using those two words in the statute.
Oh, okay.
Yeah, it's that simple. So I said there's two ways generally that Congress will do that. They'll make a legislative declaration in the preamble of the statute itself, in the preamble of the legislation. In most statutes, like in most pieces of legislation, there's like a preambulatory clause that will say, whereas the taking of Mexican whooping llamas is a diabolical, reprehensible activity, and whereas Mexican whooping llamas are vital to the maintenance of interstate commerce, and whereas the taking thereof affects interstate commerce, therefore it shall be unlawful to take a Mexican whooping llama. Yeah, you can do that, or Congress can do that. And that's when issues that are generally like, hey, this is outright an issue that is just that will tend to be, like, that's what the Civil Rights Act does. Civil Rights Act says, just as generally, we make a congressional declaration that discrimination in employment and public accommodations, et cetera, affects interstate commerce in a way that we don't like. And so Congress, we have the power to regulate interstate commerce, and so we're going to do everything. We're going to say that's unlawful now. When it gets to more specific crimes, Congress will make the affecting interstate commerce an element of the crime. So, for instance, like a crime like, murder, okay? Murder has certain elements. The taking, the unjustified taking of a human life by another. There are different elements of each crime. And what Congress will do is, in order to bring a certain crime within the purview of its power to regulate under the Commerce Clause, is it will make the affecting commerce one of the elements of that crime. So if the prosecutor finds a case and they're like, I don't know if that's affecting commerce. Even though that's been this kind of activity, I can't prosecute that because it doesn't meet this vital element. Does that make sense? That's what I mean by that's what the court means by jurisdictional
Somebody
rule.
declare and say, yes, it does? He said,
Well,
no, it doesn't.
if it's an element of crime, the jury has to find that too. And then prosecutors will tend to stay away from that because on appeal, those issues are right. If you have a case that's factually on the fence, whether it's affecting commerce or not, prosecutors don't like to deal with those too much because they don't want to be tied up in appeals most of the time. I lost my train of thought. Where was I going? Where was I going with that?
That helps some.
Totally.
That's okay.
Yeah, totally lost my train of thought. It's been a long day.
We need a break.
Yeah. Okay, so now we're done with the Commerce Clause. Yes, ma'am.
Just one question
Yes, ma'am. Certainly.
Why is it that Congress, to my knowledge, has never passed a law against drunk driving or intoxicated driving where there's a death?
Well, because tell me, all right, let's analyze this. You could have Congress could pass a law, maybe they could pass a law so you can't operate a vehicle while under the influence on the interstate.
Is there is no-
To my knowledge, I don't know if there is. And I think that they found no reason, because frankly, it's just something that the states have always enforced. Congress, believe it or not, is not in the business of just doing things just because they can. If the states are already doing a good job of enforcing something, taking care of something, then they don't want to encumber the federal law enforcement and the district attorney's office with all kinds of new cases that would be within the federal system when the states are doing a good job of taking care of it.
But for a long time, they were not in terms of enforcement. I know
Mhm.
that NITS has spent a lot of money and a lot of effort for years
Mhm.
to get states to tone their laws, lower the DUI limits.
Yeah. Well-
And do good enforcement, trying to get convince the states to do that.
Yeah.
Money, everything to do it.
If you,
Federal action.
yeah, well, the case that we're going to talk about probably beginning of the class next week, South Dakota versus Dole, is exactly that. Except Congress wasn't acting there under the Commerce Clause. Congress was acting under this taxing and spending clause. They had sent grants. They'd given grants to the states for highway construction, with the conditions that the states must maintain the drinking age of 21. Yeah, so that's what's going on in South Dakota v. Dole. So hold off on that till we get to that case, which will probably be beginning. If we can move quickly through these, we may talk some of it by the end of class today, but I don't know. All right, but it's a good point. It's a good point. All right, taxes. All right, I was hoping this would have been last week's class since it was right after April 15th, but here we are the week after. But okay, taxation. Let's pull out our handy-dandy Constitution. There are 4 different provisions that are at play here regarding taxes. Article 1, Section 2. You'll notice so it's on page 1 of your handout, this big paragraph right here in the middle of the page. Representatives and direct taxes shall be apportioned among the several states which may be included within this union, according to their respective numbers, which shall be determined by adding the whole number of free persons, including those bound to service, for a term of years, excluding Indians not taxed, 3/5 of all other persons. So this is talking about direct taxes, Congress's direct taxes, required to be apportioned on the same basis upon which representation in the House of Representatives is figured out. So what are direct taxes? This is a distinction we don't hear anymore, but it used to be an important one.
They're charged to the states, I believe.
Well, they're not charged to the states necessarily, but they are imposed with reference to the population of each state. They're apportioned to each state.
Not to the individual.
Well, that's key actually. They're not direct. They're not directly to the individual. So an example of a direct tax would be, well, here's a good example. Look at Article 1, Section 9. If you want a good example of a direct tax, Article 1, Section 9, that's on page 4 of your Constitution. Here's Section 9. If you go down 1, 2, 3, 4 clauses, it says no capitation or other direct tax shall be laid. So an example of a direct tax is a capitation tax. Now, what's a capitation tax? I didn't know before a couple weeks ago. I had to look it up. Capitation tax is poll tax. It's a tax that says, hey, you're a person. Just because you're a person, you owe the government $250. Just by being a person, just by having a head. If you're headless, then you're good to go. But just because you have a head means that you owe X amount of money. Not because of any transaction or any event that has transpired, just because you're a human being and you're in this country, you owe money. That's a direct tax. Now, the courts, from the very earliest days of the Republic, have been very liberal and broad when it comes to what they're willing to not call a direct tax. For instance, one of the very first decisions from the Supreme Court, even before John Marshall was on the court, was a case called United States versus Hilton, which involved Alexander Hamilton's proposed, it was his idea, his tax on carriages. And it was the federal government put a tax on fancy carriages. Now, somebody challenged this law because they were really rich and had a whole bunch of carriages. And they said, hey, this is a direct tax. The Constitution says no direct tax shall be laid unless in proportion to the census. And this was passed directly onto me, the owner of many carriages, without any reference to apportionment. And the court says, no, it's not. It's a tax on articles. An example of if it were a tax on real property or appurtenances thereto, like fixtures on real property, then that would be a direct or capital or head tax. But just articles that you own, taxing those, or like for instance, like an excise tax on whiskey, that also happened under the Washington administration, or Alexander Hamilton's economic program, that was not a head tax. That was just a tax on articles that are owned by people. So that was the issue. So I've included here in this handout that you got last week, kind of a brief history of federal taxation. I wanted to pass this out. Forgot about this. I'm going to pass this out. Pass it around yourselves. This is the very first Form 1040 from 1913. Yeah. Along with instructions. So pass that around. That is the very first edition of the 1040 form.
What would it mean to have a carriage tax that wasn't apportioned? I don't see how it relates.
It would, I don't know. It would have to be, Congress would have to pass it with reference to how many census people are in the state. And I honestly don't know the answer to that. Because
What to do with other people and what they have carriages?
Yeah, it's such that if you live in a lowly populated state, you're going to have a different tax liability than somebody or it's actually meant to be, it's somewhere in the middle that Congress is not going to, because, under the Articles of Confederation, one of the big problems was the national government didn't have no money, because the way the national government was funded was, all of the states owe voluntary dues. And if you want to pay them, great, we need the money, but if you don't, there's nothing we can do about it. So the national government was broke. Couldn't raise an army, couldn't do nothing. That was a problem, one of the reasons for the Constitutional Convention. So the direct tax was to avoid a scenario, the prohibition on direct taxes was to avoid, scenarios where you had, hey, Rhode Island, you owe Congress $400,000. Virginia, you owe Congress $400,000. And also the scenario, everybody in the country directly pay Congress $5. Both of those would have been, in order for Congress's direct taxes on people, they have to be apportioned. consistent with the census, the same way that the apportionment for representatives in the House of Representatives is. Okay, so that was under the Articles of Confederation. So after the Constitution in the early Republic, all the way up until the antebellum period, the Constitution fixed this problem and gave the government much broader powers to tax. And then you had quite a few of these different taxes under Alexander Hamilton's program, except the issue was Alexander Hamilton's program was kind of cut short in 1800 when what happened? Who was elected president? Thomas Jefferson. And then what faction came into power? The Republicans. Now, when we've made reference to the Republicans that came to power in 1800, that is not the modern day Republican Party. The GOP, the Republican Party of today, actually came about in the late 1850s. That's the party of Abraham Lincoln. Not the same thing. In fact, what's ironic is that the Jeffersonian Republicans were the prototype of what would eventually become the Democratic Party under Andrew Jackson. It's counterintuitive, I know. But when we made reference to Jefferson and the Jefferson Republicans, it's actually the Democrats, not the Republicans of today. Where was that? Okay. So before the Civil War, in between the era of Hamilton and the nationalist federalist scheme of taxation and the Civil War, you have a federal government that's not very actively taxing. And that's for a couple reasons. Most of the revenue is coming in through taxes and through tariffs and duties on imports. And after the Louisiana Purchase, where you've more than doubled the size of the country and you have all of this open western land that Congress owns, Congress is bringing in revenue from the sale of western lands. And so Congress is not taxing the American people very much, if at all. And also it goes hand in hand with the fact that Congress was not really spending that much money. Congress was not maintaining any kind of national army. Congress was maintaining a very small navy. Congress had virtually no form of public welfare that it was maintaining. All of the expenses that went into just normal government was done through the state governments. And Congress was not taxing very much of it all because Congress was not really spending that much money. But then you have the Civil War. With the Civil War, you have exigencies in the midst of the war that necessitate a whole lot more revenue. And so in 1861, Congress passed what is truly the very first income tax. And then in 1862, Lincoln creates what would eventually become the IRS. And then in 1894, Congress passed another income tax. And this tax is very strange. It was 2% of income that you made over $4,000 in a period of 5 years. So if you made $5,003 over a 5-year period, your tax liability would be, or let's put it like this. If you made $5,010 in a 5-year period, your tax liability would be 2 cents, right? Or no, 20 cents. Man, I am losing it right now. Pardon me. 20 cents. Okay, that's different today than when there's graduated, and it's in 1 year rather than a 5-year period. So this was seen as a very progressive tax in 1894 because you had a different political environment where you had different political groups that were advocating for more aggressive federal taxation. People who wanted the federal government to be more robust in establishing national infrastructure and in having a more robust regulatory presence in the national market. And so they advocated progressive graduated income tax. And so that's what you saw in 1894. However, in 1895 And this is in the midst of this 1895, in the midst of what era of the court? Remember the Lochner era?
After the war.
Well, it's after, so it's the postbellum, it's after the Civil War, but from around about the late 1880s until 1937, you have an era in which the court is very hostile to anything that touches or concerns contract rights or industrial prerogative or basically they're very laissez-faire, and they're very hostile to any kind of government activity that affects the economy. And so in 1895, the Supreme Court struck down the 1894 income tax because the court said this was an unapportioned direct tax. The government's argument was, we're not taxing people directly, we're taxing an event, we're taxing their making of money. The court didn't see it that way. The court saw it as you're taxing people, it's a capitation tax. It may not be everybody pay us $200, but it is everybody pay us according to your income just because you have it. And so this is the Pollock versus Farmers Loan and Trust Company case. And this ruling essentially rendered all federal income taxes unconstitutional. But at the same time, because of the spirit of the age, the progressive, you had the populist movement in the latter part of the 19th century, and then you had the progressive movement that kind of got into the mainstream of both mainstream political parties. You had a very high public demand for income taxes, and so they eventually passed a constitutional amendment, the 16th Amendment, that overruled the Pollock case. And so the 16th Amendment, let's go through and read it. Pull out your Constitution, let's figure out what page it's on. Here we go, it's on page 11. Congress shall have power to lay and collect taxes on income from whatever source derived without apportionment among the several states and without regard to any census or enumeration. So you have an exception here to the general prohibition on direct unapportioned taxes for income taxes. And so the Supreme Court's decision in Pollock is overruled. Now the federal government can tax incomes. And so that was in 1913, and that's why I passed around the very first 1040 form from 1913. Do you have a question, Mr. Barber?
Was it easy to get the states to ratify this?
Okay. My understanding, if I can recall, it was by like 1916, like it took 3 years to get a sufficient number of states. And I think it took 30 states at that time to ratify it. And so it was pretty quick to get it ratified, because there was such a public, kind of a public demand for the federal government's ability to tax incomes. Okay. So then, while that's clear, we get into the difference between a direct tax and an unapportioned tax. That has not been an issue ever, to my knowledge, since the 13th Amendment. I cannot think of anybody who's ever succeeded in challenging any federal tax by arguing that it wasn't direct, or was a direct tax that it was direct and unapportioned. So that's not really a distinction that's at issue now. Another distinction that was important in this period, but is less important today, the distinction's kind of been erased, as we'll see, is distinctions between acts of Congress that require penalties, like fines, and acts that are truly taxes. For instance, Congress can tax something because they don't want it to happen. Congress can lay a tax on, let's say, because during this period, the Supreme Court had struck down a law, or let's say the case where Congress the court said Congress could constitutionally regulate interstate prostitution. What if that had come down the opposite way? And the court said, no, that's outside of the guise of commerce. Could Congress then just lay a tax on prostitution and say, we're going to charge a $500 tax for every instance of every transaction of prostitution? Could Congress do that? They call it a tax, but in reality, it's a penalty. It's in the form of a tax, but in substance, it's penal in nature. It's a fine. It's a criminal fine. So that's what's at issue here in the next couple cases. In Bailey versus Drexel Furniture Company, what was at issue there?
Child Labor Tax Act.
Yeah, remember when we were talking about the Commerce Clause, the Hammer versus Degenhart case, where Congress said, tried to pass a law saying any good that's made or manufactured with the use of child labor cannot cross state lines, cannot transport those goods across state lines. And they did that under the guise of regulating commerce. And the court says, nope, what you're doing here is not regulating commerce, you're trying to regulate labor conditions. And that's a local issue. Now, Hammer versus Degenhart was eventually overruled, but this is the same issue, but not in the context of the Commerce Clause, in the context of the Taxing and Spending Clause. Now, there is a section that we have not looked at yet of the Constitution. It's in Article 1, Section 8. And I believe it's the very first or second clause. It's going to be on page 3. Yeah, the very first clause. Article 1, Section 8, of course, is the litany, the laundry list of the different enumerated powers of Congress. So it says, the Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, excises shall be uniform throughout the United States. This clause is referred to as the Welfare Clause because it vests Congress with the authority to tax and spend for the general welfare of the people. Now, the issue that had come up in the early days of the Republic was whether this clause was made with reference to all of the subsequent clauses that came after it, or if it was a separate and distinct power within itself. What I mean by that is Congress's power to tax and spend exclusively confined exclusively to the end of pursuing any of these other powers, regulating commerce, establishing a post office, constituting tribunals inferior to the Supreme Court, provide for punishments of counterfeiting? Can Congress only tax and spend to the end of pursuing any of those other enumerated powers? Or, so that was Madison's view of the Taxing and Spending Clause. That was James Madison's view. Alexander Hamilton's view of the Welfare Clause was that it is a clause that is separate and distinct within itself. Congress can spend and tax to the end of, can spend to pursue ends that it does not, to do things that it does not have power to do under its other enumerated powers. If Congress has money, it has the prerogative to give that money to whomever it wants, so long as it doesn't violate any negative prohibition in the Constitution. For instance, Congress cannot give money to send missionaries overseas to spread a particular religion, violate the First Amendment, or anything like that. But Congress can provide money to the states to do something that it otherwise could not do. So do you see the difference between Madison's view of the Welfare Clause and Hamilton's view of the Welfare Clause? Any questions? Madison said Congress can only spend and tax to the end of its enumerated powers. Hamilton said taxing and spending is an enumerated power within itself. It's its own enumerated power. Congress can spend on whatever it wants. So in the Bailey case, you had Congress taxing child labor, laying a tax on companies that had employed child labor. What did the court say? Is this okay or not?
No.
Struck down that
Why?
criminal penalty.
Because it should be
Oh,
It's,
it's
left
not
to the
aimed at
states.
raising
state
revenue.
prerogative.
Is the purpose of this tax to raise revenue?
No.
What's the purpose of the tax?
To stop
Regulate
child
labor.
labor.
To regulate child labor. Congress is trying to do the same thing it was trying to do in Hammer versus Degenhardt. Congress, you're not trying to get revenue here the same way that you were not trying to regulate commerce earlier. You're trying to regulate labor conditions, and that's for the states. Now, granted, that era would, in most of the cases in that era, the Lochner era, would be overruled. Now, Bailey versus Drexel has not been explicitly, hey, this is bad law, removed. But what Bailey stands for, Bailey is functionally not good law anymore. So the next case we have is United States versus Butler. And we're back to our old friend, the Agricultural Adjustment Act. The same act that was at issue in the Wickard versus Filburn case. Except this provision of the AAA was not the quotas, it was a processing tax on certain agricultural commodity. It had the same goal in mind, regulating supply and demand, but from a different angle. So this was a processing tax on cotton. And there was somebody who was involved with a cotton mill who challenged the tax. And his argument was Congress can only, he argued from James Madison's perspective. He used James Madison's view of the welfare clause. He said Congress can only tax and spend to the end of its enumerated powers. There is no enumerated power at issue here when it's imposing this tax. Did the court agree with him? Did the court accept James Madison's view of the welfare clause?
Yes.
They did.
It says the AAA's processing tax violated the Constitution.
Was it for that reason, though?
No.
Again, they were trying to regulate something that was within the states.
That's a secondary issue. But as far as the scope of the taxing and spending clause, the welfare clause itself, did the court adopt Madison's view or Hamilton's view? The Supreme Court rejected Butler's restrictive interpretation of commerce's taxing and spending power in favor of a more expansive interpretation under which Congress's power to tax and spend is substantive and is separate and distinct from its other enumerated powers. It's Hamilton's view. The court adopts a very broad view of Congress's ability to tax and spend. But it's still unconstitutional. Why?
Because it's the states.
Because of the states. Why?
It's the authority of the states.
Because the court is saying, is this really, you're calling this a tax, Congress, but is this really a tax? No, it's a regulation. It's a fine. And if and this is 1936. It's before 1937. This is the last tail end of the Lochner era. And so the court says, no, Congress cannot use its spending power as an enforcement mechanism. You can't tax people to enforce policy. It's the same principle from Bailey versus Drexel Furniture Company. But then, Between 1936, we've talked about that. I was talking about this with Dr. Davies earlier about how 1937 was kind of a watershed year in the Supreme Court, and things began to change. This is the year that Jones and Laughlin was decided, the year that the court did almost a 180. So, and we have a couple of cases decided in that year, both of them against Mr. Davis, who was the head of what was then, I don't know what it's called. He was called the Collector of Revenue, was his official title. He was essentially the head of the IRS. He was the head revenue man for the federal government. And so in Helvering, both of these cases involve challenges to the Social Security Act, which is a key New Deal legislation. And so in Helvering, the issue was, is Congress's creation of an old age pension system? We understand Congress is taxing and spending to create this system. But is this taxing and spending for the general welfare, or is this only taxing and spending for elderly people who can't work anymore? Is the creation of what is essentially a contributory insurance program, is that in the interest of the general welfare? It doesn't affect everybody. You have to be, it's not for everybody. It's for a small subset of Americans.
If your parents don't have any money, that hurts you a lot.
Mm-hmm. Yep. So the court.
It will be for you.
Exactly.
Everybody's going to get old.
Yep. The act was a valid exercise because it was for the good of all, and it was spending for the general welfare. So the court is very differential. That term general welfare read very broadly, very broadly. So everybody's growing old, and everybody is affected by the Social Security, by this program. Now, the next case, the Steward Machine case. Now, let me apologize. When I typed this description up, I had the state of mind about like what I have right now, where I'm really scatterbrained and exhausted, and I left out a whole bunch. So let me elaborate on this case here. Essentially, what's going on here is the one component of the Social Security Act of 1935 is it created not only old age pension, like retirement benefits, but it created unemployment. And it imposed a tax on employers, and it also allowed the states to enact their own workers' compensation. I said unemployment, I meant workers' compensation. And to enact their own workers' compensation schemes. And if a state's workers' comp program met the standards for congressional approval, then the employers in that state could credit 90% of the taxes that they paid to the state system and only pay 10% of what they would have originally owed to the federal government. Does that make sense? So if an employer owned $100,000 in revenue under the Social Security Act for the workers' comp scheme, but the state in which that employer lived had its own workers' comp scheme that met the standards of approval under Congress's standards, then they would only have to pay $10,000. If they had paid $90,000 to the state, they would only have to pay $10,000 to the federal government. So Steward Machine Company's argument is this is effectively coercing the states to enact federal legislation. Congress is taxing and spending in a way that is coercing the states to enact, to be branches of the federal government. So what did the court say? And so therefore it violates the 10th Amendment. That was the argument. What did the court buy this argument?
Tax did not coerce the states.
That's right. because it would benefit both the states and the federal government. States were not being coerced. Okay. We're going to come back to that notion. Next time, we're going to talk about the Dole case, which also involves money being given to states and whether or not that's, and money being taken away from states, and whether or not, and in what cases, that might be coercive in violation of the 10th Amendment. So we'll finish up talking about taxation. There are some handouts here.
I passed them out.
Pass them out. Everybody have a handout for the National Federation of Independent Business versus Sebelius case. You will have a one page back in front that describes the issues and the arguments, and you have a table, another page that has two tables back in front that reflects the decision. That is going to be our grand finale case, and it is very complex and very interesting.
This is next week?
This is what we're going to talk about maybe for the next 2 weeks. It's a very complex case. Very interesting, though. Any questions? I will be up front.